Okay, we are going to briefly talk about an IRAC brief. Now, this is the brief where we're talking about summarizing a case, and if we're up in front of a court of appeals or even a trial court making an argument, I might have one-page summaries of every case so that when a court says, well, whoa, Ms. Ziegler, what about Smith versus Allen? I'll say, oh, Smith versus Allen. Oh yeah, that was the case about XYZ, and here's why it doesn't apply to me and my client. So they're really helpful for oral argument. They're also really helpful when you want to sit down and write a big old persuasive brief for a court. You have all of your case summaries with you, and we do them a certain way for a reason. And I'm going to explain it to you. So sometimes we'll call it an IRAC brief, sometimes we'll call it a FIRAC brief. I grew up on IRACs. FIRAC just adds facts, and so if you're doing a FIRAC brief, it just means you put the facts of the case first. I tend to do IRAC because FIRAC briefs are a summary of a case, but you can use the IRAC format in everything that you talk about because it's super simplistic. And so if I'm analyzing an issue in my own case, I will IRAC that brief, and so that format is what is more useful across the board. All right, so the I in an IRAC brief is the issue. It's the legal question. It is always in the form of a question. So if you are, let's take a case that everybody knows, doesn't matter whether you agree with it or not, Roe versus Wade. What is that legal issue? Whether or not pregnant people have the constitutional right to an abortion. That is the legal question. Do pregnant people have the constitutional right to an abortion? That's the legal issue. Now, when finding out what the legal issue is the most important part of figuring out a case. If you look at, let's say, the case of Katzenbach versus McClung, that's a tricky one. Other case, like Roe versus Wade, is easy. You can look at that and say, yeah, the issue is whether it's constitutional or not. Obergefell, that's the gay marriage. Is it constitutional? Do we have a constitutional right to marry someone of the same gender? That issue is easy to spot. But issue spotting over time becomes more difficult because cases become more complex and issues become more complex. You could have more than one issue in a case. You can have, let's say, a constitutional case where equal protection and due process are both issues. The case may win on one, both, or neither. So figuring out what your legal issue is the most important thing. The rule. The rule is the law that the court used to make its decision. Sometimes that's a test, and so the court can apply a test from another case, or the court can look at a statute or look at other precedential cases. The rule is the rule of law that was applied in a particular case. So for instance, in Roe versus Wade, we might have the legal issue being, do we have the Constitution, is abortion a constitutionally protected right? Notice how I switched up the language. 5 lawyers would write 5 different issues for any given case. There's no formula to it. It just has to have all the right stuff in it. So is abortion constitutionally protected could be a way to say that. The rule of law that was discussed in the case is the constitutionality of it. So it would have been Roe versus Wade was, I think, due process and the right to privacy. That's what the big rule in that case was. That the court has found a right of privacy to exist in the Constitution. There's no specific constitutional clause or amendment that gives us the right to privacy. It's like a pendulum. It swings through a bunch of different constitutional provisions, and the right to privacy was really the constitutional rule of law that the court applied. All right, toughest part. The analysis of the court case is the why. Why did the court rule the way that it did? And I'm going to jump down real quickly and come back to this. because the C is the conclusion. It's the what. It answers the question and the issue. So if I'm writing an IRAC brief, especially if I'm starting out, I look at the issue first, then I do the conclusion, then I'm going to come back and do the rule and the analysis. Why? Because in my mind, and this is personal preference, I like to know what the issue was and what the court decided so that I can focus my analysis correctly. In a 60-page Supreme Court opinion, your eyes can cross reading all of that. If I'm looking at Roe versus Wade and I'm trying to find out the why, and I know the what, I know that the answer to the legal question of is abortion constitutionally protected is yes. It's always, when you write it out, you're going to write it answering the question. Is abortion a constitutionally protected right? Yes, abortion is constitutionally protected under the right to privacy. We're just going to shortcut that. If you were reading the case, you would look at the words the court used and use some of them. Remember, you cannot plagiarize an IRAC brief. It's not possible because you're literally just talking about what the court decided. And if you stick to the words of the court case, they're going to be there. The only way you could mess that up from a plagiarism standpoint is if you improperly cited something that was cited in the case. So don't worry about it. Issue, conclusion answers that question. The rule and the analysis, the rule is going to be pretty short. The issue is going to be a question, one for each rule, or one for each issue rather. The conclusion is going to be really short. Here's where your meat is. The why section of the brief. That's going to be why the court decided that we have privacy, number one, because remember that's not a specific amendment or specific clause, and so we've got to talk about that a little bit. We're going to talk about why that applies to medical decisions. We might define this as a medical decision. You're going to have to look at the case to determine the why behind that. That's the toughest part. It's the longest part, and it takes a practice to figure that out. But if I'm in front of a court and I'm making an argument, there's a reason why we don't always see the facts first. Because the facts don't always matter. If I'm arguing in front of Supreme Court or an appellate court or whatever, I want cases that, do I care if the cases all have the same facts? No. Here's why. Sometimes I do, but let's say the issue that we're talking about is a bad car search. So I'm in court on a criminal case, and I've got a car that was searched. The police searched a car, and I think it was a bad search, and so it's a violation of my client's constitutional rights, the Fourth Amendment. And does it matter whether my client is facing a drug charge, an illegal firearm charge? So they search the car. It really doesn't matter. And we'll talk about relevant, irrelevant facts at some point. It doesn't matter if the police officer found one joint of marijuana in a state in which it is still illegal or 7 severed heads. It does not matter. That's why sometimes we don't rely on the facts as much, because some of those sexy facts I would want to know. I would want to know if it's 7 severed heads or if it's just a joint. I would want to, or shake, some shake, which is like marijuana dust. A jury is going to want to know. We don't care for purposes of an IRAC brief, and that is counterintuitive for many of us to get our heads around. It doesn't matter what that trunk was filled with as long as it was illegal. That's all that matters. So, am I going to get, if let's say it's murder, let's say they found the seven severed heads, am I going to do some research on severed head cases? No, because you're not going to find very many. Hopefully, you're not going to find very many in your jurisdiction of severed head cases. I'm sure there are some somewhere. And let's say the reason that I think it was illegal is because the police officer stopped the car because it did not have an illuminated license plate. Is that a good search, or is that a good stop or a bad stop? I don't know. And I don't know what jurisdiction you're in. So all of this matters. What I'm going to find are cases that involve stops, car stops, and why the cars were stopped. I might do a little research on whether or not, might there be a case in my jurisdiction that says you can't stop a car just for having an unilluminated taillight or license plate? Yeah, those are the cases I'm going to talk about. Not all murder cases, not all severed head cases. The cases where the issue is this a good stop? Am I going to look at the facts of the stop? Yes. But does it have to be a license plate case? No. It can be a stop for something similar. Let's say a license plate violation in Indiana is a non-stoppable offense, meaning I can't stop your car because of it, but I can give you that ticket if you're already stopped. I might look at other cases that involve similar infractions. And I'm making this up as I go along. This is not necessarily law, so don't think about that. But think about why we look at these cases. I want to have cases that have the same issue, not necessarily the same fact. So if I'm arguing that suppression or that case, I'm looking at all these different illegal stop cases so that I can put them together and argue that all of these cases with the same legal issue add up to not guilty, add up to not a motion to suppress, add up to my client walking and not being convicted. So when I'm actually using an IRAC brief, this is what matters the most, and this, because I can have a stack with the same issue. But if they're all constitutional, if they're all good stops, that is not going to help my client. That's the stack of briefs that the prosecutor is going to have, not me. So I want to make sure that I have the legal issue correct, and I want cases that support me and support my position that the severed heads should be suppressed. So that is what an IRAC brief looks like. Issue spotting is the single biggest thing that you have to get down quickly. Now, that's with a court opinion. Can I also IRAC or use this analysis for a predictive brief? Yes, if I am given a fact pattern by my senior attorney and the attorney says, here, tell me whether our client wins or loses. I am going to determine what the legal issue is in my case, and sometimes the senior attorney will give it to you and they'll say, hey, you know what, take a look at this environmental law case. I am not sure if this toxic tort situation, I'm not sure if we have causation here. Take a look at it. And so I'm not sure if we're obligated to pay under Superfund or not. I'm going to figure out what the legal issue is first. I will use the facts. I'm not saying to disregard them, but they're not as important as they seem. I'm going to figure out if I'm IRACing like a brief I'm writing for a client. I'm not going to do issue and then conclusion because we don't know what the conclusion is yet. You do if you're briefing, if you're making a court summary. I'm going to find out what the legal issue is. I'm going to look at what they said, come up with what the rule is, and then render a conclusion. Yes, my client has to pay under Superfund, or no, my client does not have to pay under Superfund. So I'm going to use the same structure with everything I write. Now, does this mean that legal writing, the process, can be boring? Yes, but it also makes it less intimidating. There is a formula behind it. Judges expect to see it, bar examiners expect to see it, for the reason that when I'm reading something as a judge or when I'm arguing in front of a court, I need to know these issues. So if it's in the same place in every brief, it makes my job that much easier. So when you have a bar exam question and it's a torts question that says, is so-and-so liable for, is A liable to B for negligence? That's my issue. Is A liable to B for negligence? The rule is duty, breach, causation, damages. You'll learn it later. The analysis is, yes, because they breached a duty, blah, 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 blah. They breached a duty by this. Here's what the duty was. You're going to lay it all out in an analysis. And then the conclusion, yes, A is liable to B. This structure you will see over and over and over and over and over again. It should make legal writing much less intimidating. It isn't like you have to come up with the organizational structure on your own. We're not hiding any balls. We're looking for issues, conclusions, and analyses. And we're going to stick the rule in there somewhere. It's the same every time. Learn it early, learn it often, just like voting, right? But it makes it less of an art and more of a science. And It may seem also, though, if you are a creative type, this can be pretty stifling. Your creativity can come in your persuasive briefs. That's where you get to argue, well, judge, this case doesn't really look like it's for me, but it is for me, and I'm going to tell you why. You get to be much more creative in a persuasive brief. You do not get to be creative in a predictive brief. The most creative you can be is when the law is not on your side. I struggled with that, but that may be an opportunity for some of you who like to write creatively. What am I going to say for this client? I have to come up with a creative argument, and creative arguments win. Don't discount that. But this should get rid of some of the mystery of legal writing. We'll talk about style, we'll talk about more specific organization later. But it really boils down to a formula. And once you understand the formula, legal writing is just not that mysterious, and it's just not that difficult because we lay it out the same way every single time. Once you get it, and you never forget it, and you're good to go. That's an IRAC brief. That's the IRAC format for brief, for case summaries, and for IRACing when you are writing about something a little bit larger.